Have you ever stopped to think about what would happen to everything you've worked for, your home, your savings, that sentimental jewelry, if you walked out the door today and never came back? Most of us don't like to talk about it because, let's face it, talking about death is uncomfortable. But you know what's even more uncomfortable? Leaving your family in a total financial and emotional mess because you were too busy or too scared to sign a simple piece of paper. If you don't have a will, the state has one for you, and I promise you, you are not going to like what it says. When you die without a valid will, the legal term for that is dying intestate. Now, I want you to listen to me, because this is where the fear becomes reality for so many families. You might assume that your spouse just automatically gets everything. You might think, oh, my kids know what I want, they'll handle it. Wrong. When you die intestate, you are essentially handing the keys to your life over to a judge and a set of rigid state laws that don't know you, don't love you, and certainly don't care about your intentions. The problem here isn't just the money, it's the control. By not having a will, you have voluntarily given up your power. Every state has its own intestacy laws, which act like a one-size-fits-all formula for distributing your assets. And here is the cold, hard truth: these laws often produce results that would make you roll over in your grave. In many states, if you are married and have children, your spouse might only get a fraction of your estate, with the rest being tied up for your children. If those children are minors, the court steps in to appoint a guardian for the money. Now you've got the government looking over your spouse's shoulder every time they need to pay for your child's education or health care. Is that what you want? To have your grieving spouse asking a judge for permission to use your money? And what about those of you in long-term relationships but not legally married? This is a huge danger zone. If you are not married and you die without a will, in the eyes of the law, your partner is a legal stranger. They could be kicked out of the house you shared for 20 years because your distant cousins, whom you haven't spoken to in a decade, are technically the next of kin. It happens every single day, and it is a tragedy that is 100% preventable. The fear of the unknown is what keeps people from the lawyer's office, but the known is much scarier. The known is the cost of probate. When there is no will, the probate process, the legal process of settling your estate, becomes significantly more complicated, longer, and much more expensive. We are talking about thousands of dollars in extra legal fees, bond premiums, and court costs that come right out of the pockets of your beneficiaries. That is money that could have gone to your grandkids' college fund or helped your spouse stay in their home. Instead, you're donating it to the legal system because you didn't take an hour to document your wishes. You have to ask yourself the big question: do I love my family enough to protect them from this? Because that's what a will is. It's not a death document, it's a love letter. It's a way of saying, I care about you enough to make sure you aren't fighting in a courtroom while you're trying to mourn me. Without it, you are inviting conflict. You are practically begging your heirs to argue over who gets the china, who gets the car, and who gets the house. Bitterness over an intestate estate can tear families apart for generations. Is your legacy going to be one of harmony or one of litigation? So, what is the actionable takeaway here? You need to get real, and you need to get it done now. I don't care if you think you don't have enough to warrant a will. If you have a bank account, a car, or a roof over your head, you have enough. First, I want you to understand that a will is only one part of the puzzle. You must check your beneficiary designations on your life insurance and retirement accounts like your 401k or IRA. Those designations override whatever is in a will. If you named your ex-spouse 30 years ago and never changed it, they get the money, period. It doesn't matter what your will says. Second, you need to find a reputable estate planning attorney. Yes, it will cost a little bit of money up front. But compare a few hundred or a few $1,000s now to the tens of thousands your family will lose in an intestate probate battle later. It is the best investment you will ever make. If you truly cannot afford an attorney, there are statutory will forms or online resources, but please, be careful. A poorly drafted will can be just as bad as no will at all. Third, talk to your family. Tell them where the documents are. Tell them who you've chosen as your executor, the person who will handle the paperwork. Don't leave them guessing. Clarity is the greatest gift you can provide. I want you to stand in your truth today. You've worked hard your entire life. You've saved, you've sacrificed, and you've built something. Don't let the state of California, or New York, or Florida decide where that goes. You decide. Take the power back. Because if you don't, the law will take it for you, and your family will be the ones paying the price. You are young enough to handle this today, but none of us are promised tomorrow. Get your house in order. With that said, thanks for watching, and until next time.